you can discern from Marian's comments how important education was to black citizens from their very beginning here in the state of Ohio and in Cincinnati, and the efforts that were made to deprive them of education. And that's where I want to, and of course Marian made reference to the sundown laws. They were very real. But in 1804, this was during slavery and before the Civil War. The legislature enacted an anti-immigration law that regulated the right of black or mulatto persons, your grandfather, to be in the state, to actually be in the state. The first section of this act provided that, I knew I should have turned my phone off. No black or mulatto person shall be permitted to settle or reside in the state unless he or she shall first produce a fair certificate from some court within the United States of his or her actual freedom. The second section of the act requires that any black or mulatto person residing in the state on or before June 1, 1804 to register with the appropriate county clerk, whose certificate of such record shall be sufficient evidence of his or her freedom. Section 3 of the Act prohibited all persons in the state from employing any black or mulatto person who did not have one of these certificates. Other sections of the Act prohibited the harboring of slaves and regulate the removal of slaves from the state. That was for beginnings. And the passage of the Act to provide for the support and better regulation of schools, this gets to the education, by the Ohio legislature, that was in 1829, specifically excluded black and mulatto children from attending the public schools of the state. And in the words of the Act, nothing in this Act contained shall be so construed as to permit black or mulatto persons to attend the schools hereby established or compel them to pay any tax for the support of the schools. Now, they were excluding blacks from paying taxes, but the exclusion of state law continued. That exclusion by state law continued until 1848. At the same time, the Ohio legislature, amending the acts of 1819 and thereafter establishing and incorporating Cincinnati, provided for the operation of common schools in several districts in the city. By 1829, the black population had grown to constitute just under 10% of the city's total. And competition for jobs and housing increased, and that increased the pressure on the legislature to be more repressive where blacks were concerned. And many very prominent white citizens joined what they called a Back to Africa movement to try to displace the blacks in Cincinnati by sending them to Africa. It is estimated that over half of the black residents fled the city permanently at that time. Now, in spite of these many vicissitudes, Cincinnati blacks continued to press for their educational rights. In 1830, the newly established common school board received the following petition, and I quote, "The people of color in the first ward pray that a school may be opened in it for the benefit of their children." Once again, parents concerned about educating their children. Now, this is all important because what happened when friction arose, there were disruptions, there were riots, and these were anti-black riots that were aimed at making it very uncomfortable for blacks to remain in the city. But nevertheless, blacks persisted in their desire to live here in Cincinnati, in their efforts to have the black laws that Marian referred to repealed, and in their passion for human dignity. throughout the 1830s and 1840s, black Cincinnatians petitioned local authorities for their education and their civil rights. And I could go on and on, but this is evidence that we had developed as we were preparing the Bronson case, the Cincinnati school case. And the reason we had to go back into this history was because the first attempt at challenging the school situation here in Cincinnati was a suit brought by my predecessor, Robert Carter, who had, on behalf of the Cincinnati branch, they had sued to end segregation in the Cincinnati schools. The case was dismissed, and when it went to the Sixth Circuit affirmed the dismissal of the case, and that was the state of the law. And the rationale used by the court in dismissing the case was that the segregation that existed in Cincinnati was not de jure. It was not based upon law, but upon residential patterns over which the school board, the court claimed, and the school board claimed had no responsibility. And so therefore they said the condition in Cincinnati was de facto. And if it's de facto, the federal court had no jurisdiction, because the 14th Amendment does not operate against individuals, it operates against the state. And if the state had nothing to do with the segregation in the schools, then the federal court had no jurisdiction, could not order that anything be done. That was in 1965. Well, that remained the state of the law until the 60s, when cases began to be brought in various northern communities. When I became counsel of NACP, we were getting requests from school districts here in Ohio and in Michigan and California, Boston, and New York to do something about the rampaging racial isolation of black kids in the schools and the inferior education to which they were being subjected. Well, we were faced with this decision in the Cincinnati case. And in the meantime, there had been a decision in the Cleveland school case in which the district judge held the same thing, held the same as the court did in Cincinnati. I might say the court in Cincinnati was Judge Peck, who later was my colleague, and we talked about that case many years later, and of course the law had then changed. But in the Cleveland case, the court held the same way, that the Cleveland schools were segregated not because of state action, but because of private conduct, housing patterns over which the school board had no control. So our challenge was to deal with that precept. While we were considering those cases, I had a request from the officers of the Detroit branch of the NACP to meet with them at our convention, which was meeting right here in Cincinnati in 1970. So late one night I met with the officials of the branch, and they were very much up in arms because that school district in Detroit had recently hired a new superintendent, and that superintendent decided that he was going to introduce, he urged his board majority, his board, which turned out to be a 4-3 majority, to approve a very modest desegregation plan that would have resulted in, for the first time in Michigan, certainly in Detroit, in white children, there were 10,000 of them, being reassigned into previously all-black schools. Well, that set off a real firestorm politically. Those persons in Detroit who had been joining in protests against George Wallace in Alabama Ross Barnett in Mississippi, and the events in Little Rock, they suddenly became concerned about busing. Busing was the thing, and about having white children on a reverse basis assigned to schools that were majority black. And that was the beginning of this huge battle over busing in the North. So to come back to Ohio again, we assembled a team. Of course, we had no money. The NACP had very little money. But Marian and Donald, her husband, when they came and met with me in New York, and they wanted to do something about Cincinnati, and they brought money, as did the superintendent of Dayton schools, which schools are very much like Cincinnati's, and they brought money. So we put together a research team. We were able to get funds from Ford Foundation, Carnegie Corporation, Rockefeller Fund, Rockefeller Brothers Fund, and allocations from the NACP. This research team did what I just read from in every school district that we were bringing, which we were bringing suits. And we tracked back the policies of these northern school districts back to the very beginning, and we showed that the genesis of the modern day segregation, as the school officials like to call isolation, could be traced back to governmental policies, the state legislatures. And you heard the words I read. Not only the legislatures, but the courts were enforcing those prohibitions and those restrictions against educating black children. And then when they relented a bit to admit black children to the common schools, there were no resources. Blacks had to pay their own taxes to support those schools. And then for a while here in Cincinnati, the taxes that were collected from blacks were withheld from the schools, and so blacks weren't even able to use their tax money to support the education of their own kids. So we tracked all of that evidence, and then we got to the question of residential segregation, and we showed that that housing segregation was not accidental, that it was a result of conscious governmental policies combined with private discrimination, the real estate industry, the banks, zoning laws passed by cities. All these things combine to create segregation in the cities. And as that evidence was put together, and we went to trial as we did in Detroit, went to trial in Detroit before we did here in Ohio. The judge, I'll tell you this little incident, the judge was a very fine man, and we